Our next speaker is probably more known outside of Norway than inside of Norway. He has had positions and worked in in British universities, Oxford, Cambridge, Reading. He has been the United Nations rapporteur on imprisonment. And last time I talked to him, he was in Dubai. Now he's in Oslo. Mads Andenæs, professor at Norwegian University, Oslo University. Mads.
Well, many thanks. I'm asked to show some legal aspects of the Assange case, and the easiest thing is to show how it has fared in Scandinavian courts and in English and UK courts. And you have Supreme Court judgments from the Swedish Högsta domstolen, the Swedish Supreme Court. You have a Supreme Court judgment by the UK, the British Supreme Court. And you have a number of court decisions on its way up. And the first set of proceedings relates to the extradition request from Sweden on alleged sexual offenses. That was a Swedish investigation which did not reach very far. But what it did lead to was an extradition request where the Swedish prosecution authorities requested Julian Assange's extradition to Sweden, not to stand trial, because they hadn't reached very far in the investigation. They really hadn't started the investigation in earnest. They hadn't charged Julian Assange with anything. And what is interesting with that case is that at the Swedish side, there were several challenges to this extradition request and keeping the investigation open. And the Swedish Supreme Court said in 2016, I think, that basically it was very near to being disproportionate. Said the majority, 4 or 5 judges. One judge who agreed with the judge who had prepared the case with an opinion, one judge, she dissented and said it was disproportionate on the grounds they had for this Swedish investigation, which they hadn't proceeded with. It was disproportionate to keep open for more than 5 years an extradition request requesting Julian Assange's extradition from the United Kingdom. That's quite an interesting perspective. That was very close to be what we could call a sham criminal proceeding. There was no real criminal proceeding, and it was a sham one. It was motivated by issues outside that criminal investigation. And if you mention that at a time, people would say, we have to trust legal systems. We have to trust courts which have been involved here. Although, of course, the Swedish courts are very critical of the extradition request, this first stage of the Julian Assange proceedings. In the end, just before the statute of limitation, foreldelsesfristen, would have kicked in and made them drop, or having to drop all the investigations against Assange, or drop not having started them. Well then, it came up before first instance court, Tingret in Uppsala, where the Swedish judge was very clear. She said this was clearly disproportionate. There was no way she was going to uphold the procedural request by the Swedish prosecutors, which was necessary to keep alive the extradition request to the UK. And as that is ebbing out, we hear about the US criminal proceedings, where you have secret, which, by the way, is not unusual. That is US criminal procedure. They have secret grand jury proceedings. And it's something we actually have even had in Norwegian criminal proceedings. If you go far enough back, that you have the preparation of a charge can take many steps before you then reach to the formal step that you actually issue a formalized decision, which then starts the criminal proceedings against somebody. But we hadn't heard about it. We were told there wasn't necessarily anything like that, because the absolutely first round of this had ended several years earlier. And we were told that Julian Assange was kept in the detention he was merely on account of these Swedish proceedings. That was not true. I do not believe that it is possible to keep for all those years these extradition proceedings going if they weren't facilitated in one way or another by the motive that strong security interests, strong US interests, wanted Julian Assange extradited to the US, and they wanted to facilitate this. And willing or innocently, I don't know, it could be a bit of innocence, on the Swedish side. We have to give them that. But they were used. And when we look at these proceedings today, I try to be cautious in the words I use. I still think the quite tough word, sham proceedings, are something one can rightfully use. And then, in the UK, the case which then ended up, again, we are in the Swedish extradition request, still in that yet. The Supreme Court, in its 2010 decision, divided. So 2 judges held that the Swedish extradition request was not good enough. It suffered from a set of formal flaws, and it could not be used by the UK authorities. And the 2 judges who dissented in the UK Supreme Court, well, first of all, the majority had a lot of reservations. They had a lot of reservations, but on the balance, etc., etc., we uphold this extradition request, so the decision to abide by this extradition request by the UK authorities. But there were 2 judges who dissented who said this is clearly not valid. We should not uphold this extradition request. And the 2 judges were the later president of the court, Lady Hale, and the later vice president of the court, Lord Mans. And on the points of law, which I will not bore you with because I will take at least half an hour, on those points, the Supreme Court, 2 years afterwards, changed their practice. So they say, in the Assange case we did this, but that was wrong. And then, I'm not going to say that the UK Supreme Court did anything dishonest, because I genuinely don't think they did. I think they looked at the evidence and the arguments in favor of the extradition request and against, and they honestly divided. That was a legal process. But add up also what has happened later in the English process, which I'm not going to take you into because I'm going quickly over to the international dimension. Then there's too many factors like this. There's too many points like this. The totality of this does not look good. And then, of course, we have 2 jurisdictions who fail. The Swedish. Had the Norwegians done better? I'm not certain. There's immense powers behind it, immense powers, immensely strong interests. And courts are in between, the pressures from the security interests, the established interests which wanted to punish Julian Assange and wanted even more to cooperate with US interests and upholding the law. It's an enormously difficult situation to be in, and we should be happy not to be under that kind of pressure ourselves. But the Swedes erred, the British erred. And then we can go on to the international level. So the international level was very quiet. You know, the UN bodies, there's an array of UN bodies that look at arbitrary detention and detention in the context of freedom of expression, Julian Assange. But you have to go to the end of 2015 before we get the first UN human rights body saying anything about it. And that is the United Nations Working Group on Arbitrary Detention. I had been involved with that because I was at the time the UN President Rapporteur or Special Reporter on arbitrary detention. So I was in the argument we had in this working group, which went on for a couple of years. And then at the end of 2015, just as I had left the working group, they have a vote and they decide to rule on Assange's case. And this is published early 2016. And do you remember the photo of Julian Assange outside his embassy? And he's holding a paper in his hand. And it says, the blue letter, it says UN Working Group on Arbitrary Detention and the number of the opinion. This is the first support he had, you know. And that came from this working group. And it held, and it was very tough. It held. Julian Assange was in arbitrary detention. A series of fundamental procedural mistakes had been committed, both in Swedish and English or UK courts. And this constituted a breach not only of the rules about or the prohibition on arbitrary detention, but it was a very clear restriction of the freedom of expression which couldn't be justified. And it held that Sweden was in breach of the International Covenant on Civil and Political Rights, Article 9, arbitrary detention, and Article 19, freedom of expression. And it held that the United Kingdom was the same, clearly in breach. And at this time, Julian Assange had been in this embassy asylum for a long while. And this caused some problems because people said the authorities and people who were against Julian Assange, they said, well, he had jumped bail and he was in an embassy and he could at any stage walk out of that embassy. That's no detention. The working group said, Julian Assange was arrested in 2010. He was put in solitary detention in a high security prison. And then the UN working group said this, that was disproportionate. This was a man who was, the Swedes had requested his extradition to Sweden to take part in some procedural early investigatory steps in relation to sexual offenses. Well, sexual offenses are very important, but it doesn't mean that you put a man who has been subject to that kind of extradition request in solitary detention with, in a high security prison with terror suspects, That was disproportionate. So the UN working group said this first arrest of Julian Assange in 2010, which was relaxed later on, constituted an arbitrary detention. And after the decision by the UK Supreme Court that he should be extradited to Sweden, several other procedural steps could have followed before they had extradited or not extradited Julian Assange. Well, he had every reason to expect that he would be put back into that high security regime, which in itself constituted arbitrary detention because it was disproportionate. And said the working group, yes, he has asylum in this embassy, but the moment he steps into the street, he'll be arrested again and thrown into this high security detention, which is arbitrary, which is against international law. And it bloody well should be against English law, UK law, and Swedish law too, you know, and clearly against international law. So he has every right to go into this embassy to avoid being put into this disproportionate, unlawful, high security detention. And what happens when the police in the UK carry him out of the embassy some years later? Well, he goes straight into that same high security, disproportionate detention. But the working group then went into a further analysis of Julian Assange's work, and they held that they were not convinced that the Swedish authorities had pursued this, and the UK authorities pursued this, and that neither that the court decisions had taken appropriate consideration of the freedom of expression issues. So this was disproportionate, it was wrong, and it was even more disproportionate and even more wrong in light of the freedom, or if you took account of the freedom of expression issues. And after that, there has been a series of further follow-up decisions by this working group on arbitrary detention. Well, this has taken years. So, of course, there's been a complete change of membership, I think 3 times in the life of this working group. So, and they've also looked at the prison conditions it's in now. There's been decisions by the UN Special Rapporteurs on freedom of expression, on human rights defenders, and did I mention on torture? The UN Special Rapporteur on torture has expressed very critical views, and particularly in relation to the conditions under which Julian Assange is then kept in detention. So, what does this mean? What is the United Nations? Well, the United Nations is the United Nations. What are these special reporters, special rapporteurs, special reporters? What is the Working Group on Arbitrary Detention? Well, these are specialist bodies that the members of the Human Rights Council, Norway has been a member of the UN Human Rights Council in some period during which these special reporters have criticized or held unlawful the arrest of Julian Assange. But it's basically a body elected in the General Assembly of the United Nations, and it's the 3rd highest body of the United Nations, you know, the General Assembly, the Security Council, and the Human Rights Council. And then they appoint specialists, which are supposed to be independent and highly competent. Competent, independent, independent and competent, and independent of states, to assist in the supervision, the UN supervision of what states do on different human rights fields. And they report back to the Human Rights Council or to the General Assembly, as I did when I was special reporter. And then, of course, when these matters, these cases, these decisions are reported back to the Human Rights Council or to the UN General Assembly, the states say, important work, and states should abide by the decisions or the advice given by these UN specialists. And you know, most of what we deal with in these jobs are not the UK. It's not Sweden. Well, large number of decisions will relate to arbitrary detention in Iran, China, well, even Cuba, you know. But then when there's a case in Florida, of course one has to look at it without any side and in an objective way. And when you get a case against the UK, you have to look at it in an objective way. And when it's a case like this, where everything went wrong, even though it's not politically popular to do so, you have to do your job when you have that kind of UN office. And that means even Sweden. And some of my Swedish colleagues were so annoyed. How could the United Nations criticize Swedish criminal procedure? They were so annoyed. And, well, if you read opinion, you find it on the web. You can imagine. There's a lot of people, there's a lot of drafting. It's not a perfect opinion, I must say, but it is a good opinion, and you get the arguments I just explained to you very, very clearly set out. And this is international law. So then you could say, were Sweden bound by the decisions by the working group of arbitrary detention, these other reporters, the UN special reporters? Is the UK bound? Is the UK Supreme Court bound? Well, on one level, not. They're not bound by these specialist bodies, but they are bound by international law. And then if you say, is there anybody else who's more competent to pronounce on arbitrary detention than the Working Group on Arbitrary Detention, the UN specialist body on this? That's difficult to say, isn't it? It's easy to say, but it's difficult to support this is not an authoritative interpretation or application of international law. So has the UK Supreme Court, it's now in English courts, it goes up to the UK Supreme Court, is the common Supreme Court for Scotland, or England, Wales, Scotland, and Northern Ireland. And it'll end up there, hopefully, if the appeal is allowed, it'll end up there. It has been there once before. Now, does the UK Supreme Court take account of what the UN body says? Yes, it does. Absolutely, it does. Will it do so in this case? This is such a political case that the pressure on the national judge to disregard international law is strong. Will we hope that they'll take account of international law if the case comes up there? Yes, we will. So my points are really only two. The domestic processes, the court processes in Sweden and in the UK has healthily and correctly shown that there's not only one view. So that's the impression we get. Here the courts have ruled against Julian Assange on all points, but they haven't. There's been strong dissents at many stages, and that's important to remember. When it comes to the international law treatment, where you are removed from the domestic conflicts and the domestic pressures. When you're looking at the UN, international lawyers, or other special rapporteurs or other specialist bodies, they have all, when they have looked at the Assange case, denounced the unlawful treatment of Assange, and several of these bodies, in particular, this working group on arbitrary detention has gone through all aspects of the case and held that Julian Assange is held in violation, in breach of international law. Now, should we then be very optimistic and naive in our expectations to what the legal system can achieve? No, of course we shouldn't. But we should use these arguments for all they are worth in a political discussion. And civil society must make sure that domestic courts, and now it's in the UK, and if it gets to the US, let's hope not. But if he survives that and they manage to put him before a US court, then we have to use the international arguments there. And that must be part of the arsenal of arguments we have. And I would say they should be rather decisive arguments. Am I opening up for some questions, or?
Yes, hopefully.
Yes?
Yes. Yeah. I mean, Mads, we shall be coming back to this. If there are some questions to Mads here, we have a couple of people. Okay. Rune Ottesen. Do we have, Daniel, do we have a microphone?
Do you hear me?
Very well.
Yes, I'm Rune Ottosen, head of the Assange committee in PEN-Norway, where Mads also is a member, by the way. And I support your legal arguments. And I was actually in London now at a court hearing, which is the last phase before he's extradited. And these judges, 2 judges shall now decide whether he can appeal. This is the decision. And I was very pessimistic before I went there, actually. But after listening, I thought, despite previous cases where you see they had this rubber stamp feeling, I really felt that these judges asked very critical questions to the US side and their attorney. So I have been very pessimistic. Now I'm a bit more optimistic that they actually will do a legal job and perhaps let him appeal on at least a couple of points. Thank you.
No, and I think it's important. These were 2 High Court judges who are very professional and quite elegant, aren't they? And that gives some reason for hope. If the proceedings showed not too obvious bias, we have seen some previous stages where there have been obvious bias against Julian Assange in a way which, in my view, clearly is appropriate, and they have not, which is very good. On the other hand, one shouldn't be too hopeful when it comes to this kind of legal processes because the pressure is enormous. And I think one point I didn't mention, which was quite important, is that Julian Assange has now been in detention since 2010. It is more than 13 years. And one of the arguments the Working Group on Arbitrary Detention uses is the chilling effect. They say, if somebody uses their right, their freedom of expression, and they face, and at that stage it was 5 years, 5 or 6 years in detention. Well, that clearly has a chilling effect. That is more than chilling. It basically makes people clearly stay away from this field. They don't do what Julian Assange has done. I hope people would have, but I know many people, myself included, would not be that brave. Most certainly not. I wouldn't be that brave. So that was up in the 2015 decision opinion by the Working Group on Arbitrary Detention. And that argument has been even stronger. And whereas he had this very short period in the disproportionate security regime among terrorists and others in the Belmarsh prison, which are disproportionate for terrorists as well, probably, but most certainly for Julian Assange, who's not a violent man. Well then, add those 8 years to it, and then the chilling effect is multiplied many, many times over. So in addition to what you say, so I agree with you. We hope this will now go well. We hope they will allow the appeal, which will mean you'll then have a hearing where hopefully his lawyers manage to bring in the human rights arguments with full force, the freedom of expression arguments with full force, and then let us hope that he's not extradited. But as a civil society, that's what we have to do. Organize to support that process, make sure that in the general discussions these arguments come out, including the international law arguments, and then we must steel ourselves for the worst outcomes at any stage.
Thank you. You will see that we shall